All right, well, we'll move on to the issue that Ashley didn't quite get to, but I'm sure we'll have comments later, and that is Marchant Rights. And we're privileged to have Jay Thomas, professor of law at Georgetown, who is very close to the sentiment in Congress, because he is also a sometime consultant to the Congressional Research Service, authored a report on Marchant Rights that in the CRS report series.
Thanks a lot, Steve. It's great to be back. I come here often to attend presentations, and one of my junior colleagues asked, how do I get to the National Academies? And of course I had to give the old answer, research. Anyway, it's a great pleasure to be and also see Senator Bingham, who I had an opportunity to interact with several times. All the CRS staffers love meeting Senator Bingham because he actually would meet with us in person and was one of the most well-informed members of Congress. So it's great to see you in this new role. So I've been asked to talk about Marchant Rights. I'm not one of the most impassioned players in this debate. You can find others. I'll try to call it down the middle to a degree. And just to set it up for those of you, I know we have a range of expertise in the audience. The Bayh-Dole Act is 1980 legislation. It awards title to inventions made with federal government assistance to the contractor. By its own terms, it only applies to small businesses and universities, but by presidential memorandum, it applies to any contractor. The Bayh-Dole Act endeavors to use patent ownership as a means to encourage the development of products and get them into the public. Okay, so we've heard mentioned about the difference between the development of, say, small molecules and actually shepherding them through FDA approval. Now, the federal government retains certain rights in the patents. It's got a non-exclusive, non-transferable, revocable, paid-up license for its own benefit. And of course, now we get to the topic of Marchant Rights. Marchant Rights allow the government in specified circumstances to require the federal contractor to grant a non-exclusive, partially exclusive, or exclusive license to a responsible applicant. If the federal contractor refuses to do so, the government can do it for them. No federal agency has ever exercised its right to use, has ever exercised the Marchant Right. Now, the Bayh-Dole Act dates back to 1980. Really, Marchant Rights were formed in the Kennedy administration in 1963. So we're talking about something well over 50 years that hasn't been used once, not at all. So the question is, should there be some sort of reform? And I think that was sort of the basic straight up down the middle discussion. Supporters say that they provide an unused mechanism for combating high drug prices. Others assert that Marchant Rights might discourage private investment and the often considerable effort needed to bring early stage technologies to market. Now, we heard from our distinguished speaker this morning about CRADAs. So those are basically contracts between contractors and federal agencies as well. And we heard that there was a reasonable pricing clause in CRADAs prior to 1995. Those were limited, and there was an uptick in CRADAs. Well, we heard lots about correlation and causation, friends, from our economist friends this morning. I love it when economists dabble in patents. I'm a patent attorney and used to write patent applications for a living. It's interesting. It's fun. But there was a lot of talk about correlation and causation. What I would observe is that happened in 1995. In 1996, the NIH changed its standard for accounting. Before, it only counted what we call today a standard CRADA. Those are the ones with a reasonable pricing clause. Those are the only ones that were tracked. In 1996, they added so-called materials CRADA to the list. So this is an arcane terminology out there. So of course there were more, and I also observed the NIH budget was increased by 55% from the periods of 1996 to 2000. So I understand reasonable pricing's out there. Who would want to be subject to such a clause? Of course they're going to lobby pretty well and hard. But the question is, were there other factors at work with respect to that reasonable pricing clause? The reason I'm sitting down and not going to the lectern is I like to have lots of them. I like to have the statute in front of me because that's pretty helpful if you're a lawyer, right? And so what exactly is the Marchant Right supposed to occur? Well, one of them says A Marchant right is needed if the contractor or assignee has not taken effective steps to achieve practical application of the claimed invention in the patent. Okay, the practical application is actually defined. So let's look at what it says. The term practical application means to use the invention, and here's the quote, under such conditions as to establish that the invention is being utilized and its benefits are, to the extent permitted by law or government regulations, available to the public on reasonable terms. As the statute says, on reasonable terms. Now today at Georgetown I teach patent law and I teach food and drug law, but I used to have to teach contract law. Or did you ever have to teach one of those first year topics that nobody really wants to teach? It was kind of tough for me because I don't know any contract law, but I knew more than the students did in a way. And but one thing I remember from studying contract law, a fundamental term of a contract is the price. It is the price. Okay, so if you're talking about practical application on reasonable terms, the term of any deal is the price. And it's just a standard phrasing in life on the Hill that a safe and effective medicine is neither if it is not affordable. A political reality is that drug prices is a major issue in this nation. Now, Ashley and I think we can find some common ground. Do I think this is ever going to be really a practical, widely available, useful tool generally to combat high drug prices? I don't. Obviously, Marchant Rights don't deal with regulatory exclusivities. A question I like to ask is, what is the premier intellectual property agency in this town? Some of you might say the Copyright Office, and others the USPTO. Well, if you want to count the number of intellectual property rights and see who actually enforces it, it's the FDA. It's a little surprised you had a former FDA commissioner up here talking about patent counts. Why not count regulatory exclusivities? Marchant Rights don't deal with the regulatory exclusivities at all. So there's nothing there. Oh, and by the way, regulatory exclusivities are supposed to be the intellectual property right that encourages FDA approval, right? It's the patents for development and their exclusivities for getting the product out to market. Anyway, Marchant Rights don't deal with them, probably because the Bayh-Dole Act predates Hatch-Waxman. It predates the Orphan Drug Act. So when you hear statistics about this is before and after Bayh-Dole, there was a lot of other activity, and Bayh-Dole really just reflects what was going on as long ago as the Kennedy administration. So there's a lot of other incentives that are available for drug development. But again, I don't think Marchant Rights are really going to deal with those things. You know, Medicare is a huge pool of money that operates as an innovation incentive. That's not something that Marchant Rights deal with. Marchant Rights are more like an antitrust remedy. They tend to come in too late. Generic drug companies still need to get FDA approval. How's that going to happen? Some of the Marchant Rights can't be exercised in the marketplace until all the appeals are done. We heard a comment from the mic about tricky lawyers and all their machinations. I'm teaching those people, I tell you. Okay, but it's true. This is going to take a long time for it to come together. So overall, I think it's a shame. If I told you there's something in the statute that's been there for pre-statute 50 years and it's not been used once, what would you say about the effectiveness of that legislation and its purpose for congressional inquiry? What would you say if the agencies that pay the prices for drugs have nothing to do with the decision-making about handing out these very valuable exclusivities and on what terms? Remember that when the Bayh-Dole was passed in 1980, it limited the patent right that would be enjoyed to 5 years. That was gotten rid of in 1984. So just thinking about the sort of the context of the original notion and the intention behind the statute. Does it discourage? Would Marchant Rights discourage? I don't know. It might be nice if they were used once, right? And then I think they might get out more. If I were, actually, I did patiently listen to your talk. All right, so you'll have your turn. At any event, just a few things. If I'm a drug company and I say to you, listen, I'm going to license this patent to you. I'm Georgetown University. I'm going to license a patent. I'm going to warn you. This patent can go toward the PTAB for an administrative post-grant proceeding at the patent office and be invalidated, even if you never use it, even if it's dormant. If you assert it, it might be held invalid or not infringed or unenforceable. Even if you successfully enforce it, the court may not grant an injunction in your favor. After all, that's optional based on the eBay standards. Oh, and by the way, the U.S. has a 28 U.S.C. 1498 taking, and can do that. And if the drug company says, oh, no, all that's fine. And then I say, oh, by the way, there's this 50-year-old provision called Marchant Rights that's never been used once, and that possibly around, oh, no, that's a deal killer. I will take the license under those situations. Oh, come on. I mean, that seems to be a preposterous story. If anyone's in that negotiation, call me in. I won't charge my hourly rate. I'd be happy to set the record straight about how honest they are. Again, I don't think Marchant Rights are ever going to be that tremendously effective. But to me, it is a shame that we have a provision that's been there for 50 years and not been used once. I think it's time for more oversight in this area. Thank you for listening to me.
Ashley and Artie.
So, in the course of doing the research for that drug study, and thanks to the generosity of Bhavin Sampat for sharing his laborious digitization of the Orange Book with me, I've looked at the Orange Book listings for, I think, 184 drugs. And I can, as I sit here, I can only think of one, which happened to be Extendi, for which all of the listed patents were from universities. For all of the others, the licensing and developing company also got patents which would not be subject to Marchant, and hence would marching in on the university patents would not create freedom to operate and the ability to exercise an ANDA and so forth. So that's my first point. The second point is I violently disagree on, let's use it just once, the firm belief in the academic community is that if ever once the integrity of an academic exclusive license is breached by a Marchant, nobody will ever invest or believe in an exclusive license again, and we will throw out an awful lot of babies with the bathwater. And then finally, I'm going to point to the Cystic Fibrosis Foundation. The Cystic Fibrosis Foundation invested about $186 million in Vertex's development of Kalydeco or Cambia, and I'm blanking on the name of their third drug. And they negotiated for a royalty in return for their funding, but they did not negotiate to control prices. Their chief concern was to make sure that Vertex got the drugs out there in the marketplace to ensure that their patients, their constituency, had access to treatment. I'm sure they're not happy at Vertex's prices, but they know that the patents will expire and then the prices will come down. The single most important thing with basic research is to get the products into the hands of the public and not to do anything that would deter the private sector from picking up the academic and national laboratory research and taking it to market. Thank you.
Yes.
Oh. All right, so I have 2 points, one of which has already been broached by Ashley, and that is the question of to what extent can Marchant apply to so-called secondary patents, whether they constitute evergreening or innovation. We can leave that aside for the moment. And that's a really good point. Oh, of course, Jay also mentioned there are also all sorts of other barriers to getting the drug onto the market, even if you use Marchant, such as regulatory exclusivities and the like. But I do wonder whether if NIH even broached the idea of using Marchant on the primary patent, whether that might yield some response on the part of the drug maker, whether in terms of pricing or anything else. I suspect it would, just because for the reason that it's called the atomic bomb, because it is an atomic bomb. So that's just a question. I'm not an advocate of Marchant actually for pricing purposes, but I do think that you can't have it both ways. You can't say it's the atomic bomb and then say it's going to have no impact whatsoever, because if there is a Marchant on even one patent, there's going to be some impact. Second, and this is a point about Marchant that is not directly related to drug development, only indirectly in the ways that Bhavin and Danielle talked about. So Marchant has had an impact. The threat of Marchant has certainly had an impact. So I disagree with Jay. So in the stem cell patenting situation, I think the threat of Marchant certainly had an impact on WRF's behavior. So there have been cases. Now, the petitions have not been granted by the NIH, but I think there have certainly been cases where NIH has played a very strong role in using the threat of Marchant. So I disagree with Jay on that point.
I'll try to chime in very briefly because I think you've heard enough from me. But there is sort of this generally shouted statement. Everyone in the academic community believes that Marchant will have this effect. I'm a member of the academic community. I don't believe that. I know lots of people who don't believe that. That's just sort of an unprovable statement. The only other thing I'm going to say, will the prices go down when the patents expire? I would simply ask if you're using insulin or know somebody who does, you can ask whether you really think that's true. I'll leave it at that. Thank you.